Is okay?
Yes, please.
We are live.
Members, welcome to today's ProDev Hour. The Uganda Professional Science teachers always have ProDev Hour, Professional Development Hour, starting from 8 up to 9. And today we are blessed with a council. That is the most technical term, a council. The topic today is about the rights of workers, employees, in relation to labor laws. And this is Samuel, you are welcome. We normally on this platform, we bring several resource people to talk to teachers. So today you are honored, highly honored by UPSTU to address us, you are going to address the whole nation on their employees' rights in relation to labor laws. You are welcome to the topic. I welcome you. The floor is yours now. Thank you very much. Hello, Samuel?
Thank you so much. Mr. Okelo, kindly confirm if I'm loud and clear.
You are loud and clear. I'm listening to you.
Thank you so much. It is a pleasure for me to be on this call as a presenter of this topic to the Uganda Professional Science Teachers Union.
Welcome, you're welcome. Go ahead.
My name is NDIJJO, and I'm a lawyer by profession. I work with Diamond Advocates. Diamond Advocates, we are privileged to be the lawyers of this union known as Uganda Professional Science Teachers Union. Today, we are going to discuss something that is very vital, more so to people who are above 18, because above 18, the person has reached the age of decision making, and in particular, to work. So today we are going to focus on labor relations, but in particular concerning the rights of employees to freedom of association, to freedom of conscience, to freedom of thought, based on the laws of Uganda. And I wish to start by introducing the legal framework, the regulatory framework that guides us when we are looking at the labor laws and focusing on the rights of employees. How are employees protected in respect of the work they do for the employers, and more so their rights to freely engage based on their conscience, their freedom of expression, freedom of press, freedom of thought, and so forth. Of course, the Constitution of the Republic of Uganda is the main law, because that's the grand norm. All other laws emanate from the Constitution of the Republic of Uganda. That's why it is known as the grand norm. The Constitution of the Republic of Uganda has provisions that relate or that specify relations or the freedom of employers, the freedom of employees while working for employers. We have the Employment Act, Cap 226. We also have the Labor Unions Act, Cap 228. the Labor Disputes Arbitration and Settlement Act, CAP 227. We also have the Labor Disputes Arbitration and Settlement Industrial Court Procedure Rules 2012. There are many other laws that guide employment relations, but these are the major ones, and I will go straight to the introduction of our discussion today. Of course, we are looking at employee rights, but at what point do employee rights arise? It's very important to know, when do employee rights arise? Employee rights arise when there is an employer and employee relationship. So if there is no relationship of employer-employee, then there are no employee rights. So the first thing to establish is whether there is an employment relationship. If there is an employment relationship, then there are rights, there are duties, there are obligations. And in this respect, there are two parties. There is an employer and an employee. An employer is the one employing the employee. So that contract is known as a contract of service. A contract of service, there is someone controlling the other, and the person controlling the other pays that person being controlled. So that creates an employment relationship. That's what we call a contract of service. It's different from a contract for service. So when someone says a contract for service, there is no employment relationship. For instance, you instruct someone to construct for you a house. There is no employment relationship. That is an independent contractor in law. So this introduction is important because you have to first define the relationship between the employer and the employee. Does someone qualify to be an employee before the employment rights can arise and someone can fight for them? Now, when there is an employer-employee relationship, like I said, employee rights arise. And breach of these rights results into a labor dispute. So one of the major reasons why we are on this call this evening is because we have very many labor disputes in this country. And labor disputes arise because rights have been breached or duties have not been performed. If you're duty bound to perform something in your employer-employee relationship and you fail to do your duty, then a dispute arises. So in this introduction, we define what a labor dispute is. A labor dispute means any dispute or difference between an employer and an employee, or a dispute between employees or between labor unions connected with employment or non-employment or terms of employment. So the definition is broad, but the key component here is the dispute must be connected to employment. That's the key word. There are different laws that define the term dispute. I have given you the legal framework. We can look at Section 1 of the Labor Unions Act. It defines a labor dispute. When you open the Labor Disputes Arbitration and Settlement Act, it also defines a labor dispute. So precisely, that's the introduction of what we are going to be looking at today. Now, let's focus now on the rights, on the right of employees to organize. I'm sure people were wondering, to organize what? We left it hanging such that we provoke people to think. But the right of employees to organize arises. The right of employees to organize is based on the right of freedom of conscience, freedom of expression, freedom of assembly, freedom of association. This right is guaranteed under the Constitution of the Republic of Uganda. And like I said, the Constitution is the grand norm. When we are ranking the hierarchy of laws, the Constitution comes first. Other laws follow. So the right freedom of association is provided for under Article 29 of our Constitution. But important to note is this is not just a constitutional right. It is a fundamental right because it is found in Chapter 4 of our Constitution. Ladies and gentlemen, I will explain more about the fundamental rights under Chapter 4 of the Constitution. Chapter 4 of the Constitution contains what we call the inherent rights of a human being. Inherent means the fact that you're born a human being. As soon as you're born, you are entitled to the rights guaranteed under Chapter 4 of the Constitution of the Republic of Uganda. This means the right to freedom of expression, freedom of thought, freedom of assembly, freedom of association is a birthright. What does it mean? The state does not give you this right. You are born with this right. So, members on this call, when someone talks about freedom of association, it is not the government giving you this freedom. Freedom of expression is not the state helping you to enjoy this freedom. This right is guaranteed by virtue of the fact that you are born a human being. That's why it is called a fundamental human right. All rights under Chapter 4 are inherent. We are born with these rights, so they are birthrights. So the right to organize by employees is actually the bedrock of labor unions. Labor unions refer to, a labor union is an organization of employees created by employees. This definition is enshrined under Section 1 of the Labor Unions Act. We also find it under Article, under the Labor Disputes, Arbitration and Settlement Act. So without freedom of association, we wouldn't be having many organizations, political parties, labor unions, civil societies, and so forth. So it is the bedrock of all labor unions, political parties, organizations, and so forth. Meaning, any group of people or any individual can form a group, of course with a purpose or with an objective, and no one can stop you for as long as the objective is lawful. Of course, when we talk about the objectives, the objective must be lawful. You cannot form an organization to kill people. The purpose would be unlawful, so it will be criminal. We have the right to organize provided for under the different laws. Article 40, Clause 3 of the Constitution. We have Section 2 of the Labor Unions Act. I will read it verbatim. Section 2 of the Labor Unions Act provides that employees shall have the right to organize themselves in any labor union and may assist in the running of the labor union, bargain collectively through a representative of their own choosing. This is what is commonly known as collective bargaining. When you come together, have your leaders, and they represent you in agitating for your grievances and so forth. That's what we call collective bargaining. So all those are rights to employees to organize themselves into labor unions, and when they organize themselves into labor unions, they are free to do any of those that I've mentioned, in addition to the following: engage in any other lawful activities for the purpose of collective bargaining or any other mutual aid practices, and withdraw their labor and take industrial action. So employees have the right, like I said, to associate with whoever they wish, and they can even withdraw their labor. They can stop working, they can engage in industrial action. We're in a period where different bodies have to go on strike in order to achieve what they are demanding for. So whatever they are doing is provided for under the labor laws, and they are right to demand for what they wish, but there are certain regulations that have to be followed. I'll go straight to the next slide, Mr. Okello.
Mr. Mkolele, can you take us to... Yes, Mkolele, take us.
The court has also interpreted the right of employees to organize themselves into labor unions, and it has given its interpretation. We have different cases decided by the court, and the courts have explained that indeed employees are entitled to organize, withdraw their labor, and also take part in industrial action. But of course, it should be in an ordinary manner. That means the procedural steps provided for under the Labor Unions Act must be followed. So when you look at different cases, I happened to cite for you a case. For those who love reading, these cases can be found on ULI. You can just type in to Musime Richard and 5 others versus Mukwano Personal Care Products. It's a labor dispute reference number 213 of 2014. You will get this entire case. You can read it and appreciate that indeed employees are entitled to organize themselves and can withdraw their labor and also take part in industrial action. Let's look at the basis of the right to organize. What is the basis of this right? Why did the framers of the Constitution provide for the right to freedom of association, freedom of thought, freedom of conscience, and so forth? The framers of the Constitution foresaw the need for promotion and protection of economic and social interests, political interests, cultural interests, and so forth. Now, like I said, we are looking at labor relations. In an employer-employee relationship, many issues arise. Issues of working conditions, issues of safety at work, issues of payments, where we have delayed payments. Should an employee just keep quiet simply because you are in an inferior position of employee? No. The law provides a safeguard, a protection to the workers. For instance, Article 40 of the Constitution of the Republic of Uganda, Article 40, Clause 1, Paragraph A, provides for the right to work under satisfactory, safe and healthy environment. And from this article, we have an entire act known as the Occupational Safety and Health Act. So an employee has a right to work under satisfactory, safe and health environment. If the employer does not provide such a working environment to the workers have a right to protest. The workers have a right to demand that the working condition in respect of their safety and health is improved. Article 40, Clause 1, Paragraph B, right to equal payment for equal work. So the right to equal payment for equal work is actually also protected under Article 21 of the Constitution. That is a right to freedom from discrimination. If we are doing the same kind of work, why should you pay someone more and you pay me less? And yet we are delivering the same work. So there is need, the law protects employees who do the same work. They should be paid equal amount in terms of salary. Then we have Article 40, Clause 1C, a right to rest and reasonable working hours. Even during holidays, for instance, the teachers, we have professional teachers on the call. Even during holidays, you're supposed to be paid. You're supposed to rest. That's why when you do work and it is termed as overtime, you're supposed to be paid because you have an employment contract which should stipulate the working hours beyond which you're supposed to be paid overtime. That is a constitutional right. And like I said, this is a fundamental right. We have Article 40, Clause 2, right to practice your profession. No one should stop you from practicing your profession. We have Article 40, Clause 3, a right to join trade unions, labor unions. So no one can stop you from joining labor unions. We have some employees who intimidate employees, employers who intimidate employees. That is not right because, like I said, Article 29 provides for freedom of expression, freedom of association. If I wish to join or to be part of a certain labor union, an employer has no right to stop me from joining the association. Also, if you join, let's say a labor union, let's say I am a member of the Uganda Professional Science Teachers Association. I am a member, but I have a friend I wish to join, but for him he doesn't want. Now, I have a right to join. He also has a right to join. In like manner, he has a right not to join. I'm not supposed to compel or to force that person to join the association. Just like if there is an industrial action, let's say strike, let's say science teachers are protesting, they are on strike. But then the lawyers who are not part of the Uganda Professional Science Teachers Association, science teachers are compelling them to join their what? Their strike. What's the motive of striking? Why are you forcing someone else to join the strike? So here, there is need to enjoy the right to freedom of association. if a member is interested, is free to join. If he's not interested, it is not a crime. You are not supposed to compel such a person. That's why it is called a right to join. The discretion is a reserve, the preserve of the individual. Then we have very many rights, okay? Right to equality and freedom from discrimination in all spheres of life. Spheres of life, we look at political, social, economic, religious, and so forth. So that is the basis for the right to organize. Why we have, it is basically to promote the interests of the workers. So like I said, the employer does not have any right to interfere with the right to freedom of association. Employees have their right guaranteed, and it is a fundamental human right. It is a birthright. The moment you are born with the right to freedom of association. An employer shall not interfere with or coerce an employee in exercise of his or her rights guaranteed under the Labor Unions Act. That is Section 3 of the Labor Unions Act. Now, it is a crime for an employer to interfere with the right of association of their employees. And Section 4 makes it a criminal offense. The punishment is a fine of Uganda shillings 1,920,000 or imprisonment. The employer can be imprisoned for a period not exceeding 4 years. So that means you can, once you're convicted, the court can order you to pay a fine, or they can sentence you to a custodial sentence, but not exceeding 4 years. Then in case of continuous offense, then a fine of 40,000 for every day or part of the day during which the offense continues. Let me explain this a little. We have said an employer has no right to interfere with the right of association. But then, if it is disclosed that an employer is interfering with the right of association, and you are warned or you are cautioned or it is settled, but then you continue. Each day you continue with the interference, there is a fine for each day of interfering with the right of association. In most, we have a recent example of a certain RDC. I think we must have all read about this and also watched this in the news. An RDC, I think from Kumi, who arrested the head teacher over the industrial strike of the arts teachers. That was wrong because, one, the teachers have their right to undertake an industrial strike. When someone is exercising their right to undertake an industrial strike, the intervention shouldn't be arresting, but the intervention should be finding a solution to the problem. Because an industrial strike, an industrial action is based on the grievances of the union members. So if an RDC arrests a head teacher, then that is wrong. So criminal charges can be instituted either individually or against the state, because now this is a state official who is arresting. Then let's now focus on industrial action. we have always heard about industrial action, but by law, according to the definitions provided for in the Labor Disputes Arbitration and Settlement Act, industrial action means a strike or lockout. A strike normally is by employees and a lockout is by the employer. A lockout is when the employer locks the workplace, denies the employees access to the workplace. This may be because employees have gone on strike, and because of that, he retaliates by closing the workplace. Like I said, an industrial action is a right that has to be enjoyed by employees, although it has to be exercised after following due procedure. An employee has a right to participate in an industrial action as long as it relates to a labor dispute. Different provisions provide for that. We have Section 30 of the Labor Disputes Arbitration and Settlement Act. The industrial action must be lawful because the law bars or prohibits unlawful industrial action. Section 29 of the Labor Disputes Arbitration and Settlement Act provides for that. Still, the court has provided a judicial interpretation of the right to industrial action. We have the case of Uganda Scientific Researchers and Allied Workers Union versus Uganda National Bureau of Standards and two others. It's a labor dispute reference number 31. When you type that citation, you'll get the entire case. For those who love reading, you can read it and appreciate, because now this being a labor union, some of these cases are very important to the union members and the leadership, because when you read some of these cases, more so to the leaders of the union, you'll get the knowledge on some of these principles that we are learning. So the court held that the right to industrial action is protected but strictly regulated. Failure to follow the procedure makes the industrial action unlawful, which may waive members' protections and justify disciplinary action by the employer. So here, like I said, the industrial action is lawful, but due procedure must be followed. You don't just wake up and go on strike. Procedural steps must be followed and exhausted before you declare an industrial action. So let's look at the procedure. What is the procedure? Before going on strike, before engaging in any form of industrial action, like I said, all this arises because there is a dispute that relates to employment or labor, a labor dispute. So once there is a labor dispute, what is the first thing that should be done? I'll go back to the time someone is appointed. Before you are appointed, there is no employment contract, so there is no relationship. Then once you are appointed, there is created an employer-employee relationship. Now, an employer-employee relationship creates rights and duties, and breach of which, of course, a labor dispute arises. So once there is a labor dispute, the first thing is to lodge a complaint to your employer, whether it is an individual employer or it's a group of employees. Once there is a dispute, first raise your complaint to the employee. Now, once a complaint is lodged with the employer, the employer is expected to intervene or to respond. Now, once the employer does not respond, the law provides for the labor officer or the Commissioner for Labor. So you lodge a complaint with the labor officer, and that is provided for by the labor laws that we have cited above. Now, the labor officer is expected to settle this dispute through mediation and conciliation. Mediation and conciliation, the labor officer calls the employer and the employee, and they discuss the dispute to find a solution such that the relationship is restored and people work. The labor officer has two options: to make a decision or to refer the matter to the industrial court. So if the labor officer finds it prudent to make a decision, or if the issue, the labor dispute between the employer and the employee can be resolved by the labor officer, he or she makes a decision. If the labor officer finds that the labor dispute or a question of law is arising from the dispute and he cannot make a decision, he refers it to the industrial court. But then if the labor officer delays to make a decision within 8 weeks, the employee has a right to do what we call a self-referral to the industrial court. Now, these are what we call dispute resolution mechanisms. Once all these dispute resolution mechanisms have failed to be achieved, then a labor union is free to write a notice to the employer informing him or her of an intended industrial action that is to be taken. And I wish to emphasize this, that I should have emphasized this, that a labor union may be registered or not registered. For instance, if it is a school in the staff room, you can have even a department, let's say biology and chemistry department, they can form their labor union. If they have their issues and biology and chemistry department, they lodge their complaint with the employer. It can even be registered. But of course, these procedures have to be followed. Before you can undertake an industrial action, you must notify your employer of the intended industrial action and also all the relevant authorities. The labor officer is also like an employer. He is someone who protects workers, supervises workers, and so forth. So you must also notify the labor office and the different authorities. So I'll give an example of the Uganda Law Society. The Uganda Law Society had some issues a few months back. The Masaka High Court had a lot of cases which were undecided. There was a lot of case backlog, and lawyers raised the issues. Now we have the Uganda Law Society, but it has different branches. For example, the Masaka Bar went on strike. When the Masaka Bar went on strike, the rest of the lawyers in different regions were working, but the Masaka Bar had to notify the Chief Justice, the Deputy Chief Justice, the Principal Judge, the President Uganda Law Society, the head of the Masaka Court, High Court. All those different stakeholders have to be notified of the industrial action. So the Uganda Law Society, Masaka Bar, went on strike, but after notifying all those different words, even informed the clients that starting next week, we shall not appear in court. All clients should not come to court because we shall not represent you. We are on strike. That is notification. Without such notification, such industrial action is unlawful. And I wish to emphasize that I said there is freedom of association. If a group of employees are striking, they are free to strike. If you are working in the same environment and others are striking, yet for you don't want to participate, you have a right not to participate. And then no one has a right to force someone to strike because there is freedom of association. With that, I wish to conclude because of time. And of course, my conclusion is based on the right to organize, being a fundamental right, which is guaranteed under the Constitution and all the labor laws. Employees have the right to participate in industrial action, but they should follow due procedure. Once you have followed due procedure, then the industrial action is lawful. Only proceed with industrial action after issuing a notice and after attempting all the dispute resolution mechanisms. I thank you so much for listening, and I'd like to hand over to the moderator to guide the next item, which
Thank you very much, Samuel. Thank you very much, Samuel, for your presentation. I'm happy. Today is a broad session, which we even invited other people who are non-scientists. I saw a political scientist. I think she has gone off. Grateful that, I'm not seeing her back again. She went off. And I'm seeing some NEC members. Betty is there. I can see Muindo Johnson, Musramu from Bugisu. Muindo is from Rwenzori. Then I have the treasurer from Lango sub-region. Then we have the Kigezi chairperson and Twain Elliott. Thank you for being in this session. Now we are going to question time. We are going to question time. It is open. You can raise your hand and submit your. You can raise your hand and you present your comment. You present your comment or your concern about what the council has just given us. Before we invite members, I wanted our resident lawyer, Masiku. I don't know whether she's there to give something, if she has something to add on. Can I have Masika? Hello? I'm not seeing her. She's one of the hosts to add on what Samuel has given. Can I have Masika? Hello? We're in question time. Open sharing segment. You can raise your hand, unmute, introduce yourself, and share. Me, there was I'm a teacher from Laurel Secondary School in Oyam, the host for today. Members, can we have comments? It is now open time for segment. As we wait for anybody to raise a hand and comment, can I have Betty to say something? I don't know whether Betty is there. We have lost Betty.
Yeah, I can see Isaac.
Isaac,
on
yes.
chat. He's saying he's connected from Karamoja.
Mm.
And maybe
Unmute and talk as you are concerned. You're welcome. Can you unmute and Isaac from Karamoja?
Okay, maybe
Maybe you can add something.
Yes. Yeah, thank you very much. It's understandable. Thank you very much. So what I wanted to share is that as a labor union, we are interested in members getting to know their rights and to know things to do with that concern them and how their rights can be protected. As we look at on ProDev, one of the main things that we are looking at on ProDev, we keep rotating. One of the things is to do with rights, safety policies, and dialogue. And this dialogue can cut across different labor unions. But also one thing I wanted to say, when you go to our website, we keep putting some resources. Let me share here, just a minute. So when you go to our website and you go to resources, the union has been organizing some physical and even online sessions. Like there's a time we had a presentation on labor rights administration and labor justice. That presentation is on the library. You can go on our library and you can get that presentation, which was this was a physical presentation which we had at Logview. The union leadership invited some other lawyers that were taking us through different things in terms of rights of workers. Also, some of the vital laws, like the Employment Act, the Labor Unions Act. Like in today's session, we're looking at the Labor Unions Act. And particularly there was something but this one, the council is going to clarify something. These laws keep being revised. So this one had it under, there's something here, rights of employees to organize. This is where we have been discussing an employer not to interfere with the right of association. So some of these documents are there on our website because as a labor union, this is our business. And our members need to know the context. So if there is any instruction by any labor union, we need to understand and we need to know how to handle it. Maybe my question would be for our presenter to say something about the Labor Unions Act. Was it revised? Is this the latest version? How do we keep getting new or latest copies? Because these laws keep getting revised or amended or something like that. So that's what I could say. But I just wanted also to share. Remember that this one of the segments of ProDev. In addition to academic things, union updates, we also need to know our legal. Yeah, over to you. Thank you. That's the comment I wanted to share.
So, Samuel, you can answer that as we wait for other comments.
Thank you. I didn't take note of the name of the person asking.
The person is our ICT, called Mukarele Rogers.
Rogers. Okay. I'll respond right away. The laws, all the principal laws. Principal laws means the acts. Anything having the word act is a principal law. They were all revised last year, 2024. So your website may having the previous laws, and therefore you need to update with the revised edition. So as of 1st July 2024, all the principal laws of Uganda were revised, including the Labor Unions Act. I think that answers the question. He also asked, how best can you update? Since we Diamond advocates are your lawyers, this is something we can do, because being your lawyers, we are duty bound to guide you on how to update your information with the updated laws. This is something that we are going to do. We shall get in touch with the union leadership, and we see how best you can update the laws that you uploaded, but all the principal laws were revised. And once a law is revised, it means the previous law is no longer binding. So you have to be careful, because sometimes the sections change. What was section 2 may be section 3. What was section 10 may be section 4. Even the citation may change. What was cap 6 or what was 2006. For instance, the Labor Union Act 2006, it is now cap 227, okay? So they were revised. Thank you. Any more questions, please?
Thank you very much, Council, for answering that. Maybe I also have a concern. I want you to be exact, because you mentioned that before an industrial action, there must be notification to the concerned authority. What is the time frame? Because you are so generous, could you tell the members the time frame before the impending industrial action? The time frame. Thank you.
Thank you so much. Before industrial action, the law does not explicitly provide for the time frame, but good practice provides 14 days notice. Thank you.
Mr. Okello, you were earlier calling Madam Sandra. I can see she has connected. Maybe she could say something as a council.
And add on, Masika, you can add on, please. Unmute. You are around, you are in the room. Please address us.
Am I being heard? Hello?
Yes.
Am I being heard? Hello?
Go ahead. Go ahead. Go ahead. You are allowed.
Well, I don't have anything much to add on, but rather I would like to give a formal appreciation to my colleague, We are all Diamond advocates for the fantastic presentation. I would like to say that your expertise and enthusiasm has really been truly inspiring. And I would also appreciate and recognize all the members that have been so patient till the last minutes for this presentation, and also generally associate myself with this presentation. How can I not associate myself with it? It has been so fantastic. And thank you all. Thank you, Council NDIJJO Samuel. I believe for any other further questions, we also have our website, Diamond Advocates. We are always available, and we are always at UPSTU at the headquarters every Monday and Thursday to tackle all issues relating to teachers. So thank you all, and thank you, Mr. Sam. I believe the teachers have learned a lot. They've had a blast. Thank you for the good job. Thank you so much.
Thank you, Sandra, for your insight. Now, in the chat room, I can see somebody querying that originally the time frame or the grace period for industrial action was 90 days. Council, can you elaborate more to if there is a new system in place now? Because the person in the chat room is wondering that it was used to be 90 days before you go for industrial action. You elaborate more on that. You mentioned is it 14 days? Can you elaborate more on that?
Thank you so much. Like I said, industrial action, the notice has to be issued to the employer. The notice to the employer, like I said, good practice provides for 14 days. There is no explicit provision for the time frame, but good practice provides for 14 days. So the first person to be served is the employer, and then other relevant authorities. So 14 days is good notification to the employer. You can provide any number of days, but good practice demands at least 14 days. There is no explicit, if when I say there is no explicit provision, I mean the law does not provide for the specific timelines. So when the law does not provide for specific timelines in law, then good practice takes precedence. Thank you.
Thank you very much. Thank you very much for I think the person who querying that is now has been answered. I'm now calling on the Chigezi chairperson to give a comment. Am I compiling the Chigezi chairperson? Edison, unmute and talk to your people. Edison, can you hear me? Unmute and talk to your people. Edison, are you hearing? Are you listening to us? I think we might have lost Edison. Can look for somebody else. Edison, can I have one BD first? differs. Edison, you give your concern. It seems we cannot get to Edison. Can we have one differs from Busoga? Look, have some comments. You talk to our counsel, our lawyers, and then I'm about to close this session because we are now about 9 minutes inside our prescribed time. We are supposed to be from 8 to 9. Now we are more by 9 minutes. Talk. Edison, you give us your own. Thank you, members. I think we have lost everybody who wanted to give some comment. I'm just giving 3 more minutes to wait for any comments, any appreciation. Then after that, I will close the session. I'm just giving 3 minutes because we are already 10 minutes, 11 minutes past the prescribed time. I'm giving 3 more minutes for any concern. Otherwise, thank you very much, our advocate, for this insight on labor laws, industrial action and labor laws to our workers. It is prudent enough that today you have to address us on our rights in relation to labor laws and industrial labor relations and labor laws. We thank you for being around and giving us and briefing us on matters which concern the workers' rights. I think what you have given today is very useful to us and to the entire working force. That's why today's session we had extended the link to even non-science teachers. So the way as you are presenting to not only science teachers, there were also other people in the outside the science fraternity. I thank you very much for that. I'm about to invite you to give the parting shot, the last one, and then we close this session. Samuel, can you hear me?
Yes, I hear you very well.
Giving the last parting shot, and then we close this session.
Thank you so much, Mr. Okello. Firstly, I would like to thank the Uganda Professional Science Teachers Union for this initiative. Such trainings are valuable to the nation because the lawyers know how to interpret these laws, but not everyone can interpret these laws. And like I was explaining a few things, where there is a right, there may be some exceptions, but not every Ugandan may know the exceptions. So we are privileged as Diamond advocates that we get such platform to train people, to explain to the nation about some of these laws and procedural steps that are taken. So, as Diamond advocates, we shall continue providing this guidance, and I wish to assure members that in case of any question, any inquiries, we are always available. We have even someone who sits at the office, at the union, and we also have different lawyers who can attend to you. So we are privileged to be part of this union, and most importantly, to guide you when it comes to compliance with the law. I thank you so much for your good audience. Thank you.
Thank you very much, Advocate. I think this one brings this session to a close. We shall meet next Thursday with another insightful topic. Thank you very much for all the people who attended this session. We are very grateful for you, Advocate, for listening to our call. Anytime we have challenges, you are still our what? We are still in your service. You still serve us, guide us, so that we become law-abiding union and the members all. Thank you very much for participating. I also mean gratitude to our resident council, Sandra Masika, for attending this session. Thank you very much. With the honor given to me, I declare this session